Recently, on 15th of August 2024, the Prime Minister in his Independence Day speech stressed on the importance of uniform civil code implementation across the country. So this issue has once again gained significance, and uniform civil code is a very important topic for both UPSC and civil services exams. The present central government, it is a coalition government in which JDU and TDP, they are the coalition partners, and these parties, they enjoy a substantial support from the minority community, and hence if the government needs to implement the uniform civil code, it needs to tread a cautious path because it cannot afford to anger its coalition partners, which are crucial for BJP staying in power. Now, in today's video, we are going to study about the Uniform Civil Code. What is the definition of Uniform Civil Code? What are the historical precedents with respect to Uniform Civil Code? That is, how was it applicable? Whether the Civil Code, what was the Civil Code that was applicable during the colonial era? Then we will study about the post-colonial era, about the Hindu Code Bill. Then we will see the different judicial pronouncements that have been made with respect to the Uniform Civil Code, the different cases in the Supreme Court. After that, we are going to study about Uttarakhand State's Uniform Civil Code, which has been which has been referred to the President's assent, and we will also study the shortcomings of the Uniform Civil Code passed by Uttarakhand, as well as what are its advantages. After that, we are going to read the points for and against Uniform Civil Code, and also the way forward with regard to Uniform Civil Code. What are the suggestions? So with this, we start our video. Firstly, what is Uniform Civil Code? So it is a national civil code in which all sections of society, irrespective of their religion, they will be treated as equal. They will be treated equally. And this national civil code is going to be applicable to all uniformly. So it is a uniform set of civil laws across the country. At present, Goa is the only state in the country with a uniform civil code. It is following the Portuguese Civil Code of 1867. Now the different judicial pronouncements regarding the uniform civil code. The first important judicial pronouncement was the Shabano case of 1985. And in the Shabano case, the Supreme Court had said that it is a matter of regret that Article 44 has remained a dead letter. That means the governments have not been taking sufficient steps for implementation of the Uniform Civil Code, as said by the court in the Shabano case. And the court called for the implementation of UCC in the Shabano case. The Shabano case was a case in which a 60-year-old woman called Shabano, she was divorced by her husband and she asked for maintenance. And the court, she approached the different courts, the district court and high court, and later the district court and high court, they both ruled in her favor. And the husband appealed in the Supreme Court, and the Supreme Court also ruled in favor of Shabano, and the Supreme Court said that Shabano is entitled to maintenance under the section 125 of the CRPC, and under this section 125, this section 125 is applicable to all sections of the society, to all religions, and it does not make any exceptions, so Shabano is entitled to maintenance. And when the court gave its judgment in favor of maintenance for Shabano, there were widespread protests across the country, which we are going to study in the later part of this video. At present, we are just seeing in brief which are the cases relating to UCC. The first was the Shabano case. And in the Shabano case, the court stressed on the implementation of UCC across the country. Then the court's emphasis on the UCC, it was reiterated in subsequent cases like the Sarda Mudgal case of 1995. In the Sarda Mudgal case, the court had said that conversion of Islam just for the sake of marrying again, it is not allowed, and there should be a uniform civil code across the country. These two things were said in the Sarda Mudgal case. And also in the John Valamtom case of 2003, in which a priest from Kerala, he had appealed to the court against the section 118 of one of the laws that are applicable to non-Hindus in India. So section 118 says that the non-Hindus, they cannot transfer. The section 118, it imposes restrictions. It imposes restrictions on the transfer of property by the non-Hindus in India, and so this law was challenged by the priest in Kerala, and it was declared unconstitutional by the court. We are going to study in detail about this in the subsequent slides. But the main thing about it is that in the John Tom case, the court said that AUCC should be applicable across the country. Now there are several other cases also, like the famous Shaira Bano case of 2017. So in this Shaira Bano case of 2017, the court had declared triple talaq as illegal, and the court also stressed on the implementation of UCC across the country. Then there was the famous Joseph Stein case of 2018, in which the court declared adultery as a criminal offense. The court declared that adultery is not a criminal offense, and the court said that section 498 of IPC and section 198 of the CRPC, they will be henceforth declared unconstitutional, because section 498 of the IPC was actually not gender neutral, and it was only charging the man of the crime of adultery, while the woman was exempted. Only the man was to be treated as criminal in cases of adultery. So this was unconstitutional, because both the man and woman should be equally responsible for the offense of adultery. And section 198 CRPC, it said that only the aggrieved husband of the woman can actually approach the court against the in filing an adultery case. So only the aggrieved husband has the right to approach the court regarding filing of the case of adultery. So this was also not gender neutral. So these two sections, they were struck down by the court because they treated the woman as a property of the husband. That woman has no free will of her own, and also it charged only the man with the offense of adultery and not the woman, which is not gender neutral. And also it said that only the aggrieved husband has the right to move court in cases of adultery. So these two sections were struck down, and the court again reiterated the demand for the case of uniform civil code. The court said that it should be gender neutral laws and uniform civil code across the country. So this was about the Joseph Stein case. And also in the John Paul Coutinho case, the John Paul Coutinho case of 2019. So in this case, in the John Paul Coutinho case, the court stated that the uniform civil code should be applicable across the country. The court had also praised the state of Goa for implementing the uniform civil code. Then there was the Pannalal case, the Pannalal Balsilal judgment. In the Pannalal Balsilal judgment, so in this judgment, the court took a more practical view, and the court said that one-stroke implementation of UCC across the country is not possible. So the court said that you cannot implement UCC in one stroke. So this was a more pragmatic view that was taken by the court. And if you implement UCC in one stroke, it can prove to be counterproductive, according to the court. So these were the different cases that were related to Uniform Civil Code. And also initially in 1973, in the Keshwanand Bharati case, the court had also given its opinion that UCC should be implemented across the country. And then in the National Textile Workers case of 1982, in the National Textile Workers case, which we are going to study subsequently in the slides, the court said that the court's rights with respect to implementing UCC are limited. So court has limited powers, and the court cannot act unilaterally unless the legislation supports the Uniform Civil Code. So the court emphasized on the need for a legislation. The court said that our powers are limited, and the legislature needs to take proactive steps to implement UCC, and the courts cannot do much about it. This was said by the court. So the court recognized its limitation with respect to implementing UCC in the textile workers case. But the court at the same time said that it is desirable for national integrity to implement UCC across the country. So these were some of the cases briefly about UCC. We are going to study all these cases in detail in the subsequent slides. Then we go to the brief history of the Uniform Civil Code. In 1840, there was a Lex Loci report, and it stressed on the necessity of uniformity in codification of Indian law relating to crimes, evidence, and contract. But it said that personal laws, they should be immune. They should be kept as separate, and it did not recommend the codification of personal laws for Hindus and Muslims. Then there was the famous Queen's Proclamation of 1859, and the Queen's Proclamation was after the 1857 revolt, and the 1857 revolt, as we know, one of the causes was religious interference by the British, like the greased cartridges issue. The Hindu and Muslim soldiers, they were required to bite these cartridges and bite these cartridges which were rumored to be coated with a cow and pig fat. So this was against their religious sentiments, and they were forced to do it. And so the soldiers revolted. Also, the soldiers were not allowed to go out. They were asked to go out of the country, and this was also against their religious norms, against the norms of Hindu religion, which forbids traveling out of the country. So all this religious interference had led to the revolt, and the revolt had shaken the British government. So the British government decided not to interfere in the religious matters. So in brief, we can say that during the colonial era, the criminal laws were codified. They became common for the whole country, but the personal laws, they were still governed by separate codes for different communities. So this was about the colonial era. So the personal laws were separate, they had separate codes, but the criminal laws, they became common for the whole country. Now we come to what happened during the post-colonial era, that is most important for us. So in the Constituent Assembly also there were debates regarding implementation of UCC. Finally, it was decided that UCC is to be included in the directive principles which are not judicially enforceable, because the society was not yet mature for implementation of UCC. Then we come to the Hindu Code Bill. In 1950, the Hindu Code Bill was implemented, and it was to legalize divorce, to oppose polygamy, and to give right of inheritance to the daughters. Now the conservative elements within the Hindu religion, they opposed this code, and as a result, under pressure, the government, it passed a diluted version of 4 different laws, and these 4 laws included the Hindu Succession Act, the Hindu Marriage Act, the Hindu Minority and Guardianship Act, and the Adoption and Maintenance Act. The Hindu Succession Act is dealing with the succession rights in Hindu religion, the inheritance of property, etc. The Hindu Succession Act of 1950s, it did not give the daughters any inheritance rights in ancestral property. So daughters were not given inheritance rights in ancestral property. They could only ask for right to sustenance from a joint Hindu family. So they only had the right to sustenance. They could ask for right to sustenance, but they had no inheritance rights. So this was a regressive legislation, and it continued till 2005. And finally, this disparity was removed by an amendment to the Act in 2005, and now the daughters, they enjoy the rights of inheritance in ancestral property. All these 4 laws, that is the Succession Act, the Hindu Marriage Act, the Minority Guardianship Act, and Adoption and Maintenance Act, they were passed during the 1950s. The Hindu Marriage Act regulates the marriage rights of the Hindu couples, the divorce rights, the marriage rights, etc., the right to maintenance. Then the Minority and Guardianship Act, it deals with guardianship of the minor children. The Adoption and Maintenance Act, it talks about adoption of children, what is the procedure for adoption of children, and what are the maintenance rights for wives and children in case of divorce. So this is in brief about the 4 acts which were passed as a diluted version of the Hindu Code Bill. So in brief, they were the Succession Act, the Hindu Marriage Act, which is regulating marriage of Hindu couples, Minority Guardianship Act, regulating guardianship of children, Adoption and Maintenance Act, regulating adoption and maintenance for wives and children, and the Succession Act, it is regarding the inheritance rights. Then in 1954, the Special Marriage Act had been passed, which provided for civil marriages outside religious personal law. So civil marriages of interreligious couples, like the husband and wife are from different religions, they will be regulated under the Special Marriage Act. All other types of marriages which are not covered in any of the personal laws, they will be regulated under the Special Marriage Act. Now we come to the different judicial judgments regarding the Uniform Civil Code. So what are the different judgments regarding Uniform Civil Code? We studied these judgments in brief in the beginning of this video. Now we are going to study them in detail. First was the Keshwanand Bharti case of 1973. So we know that this case is famous for the basic structure doctrine, but in this case the court also reiterated the need and importance for UCC. The court said that the government has not been taking enough steps for implementing UCC, and the court emphasized on implementing of UCC, but the court also said that we, the courts, cannot compel the government. The courts cannot compel the government although UCC is in the interest of the country, but the courts cannot compel the government. The government has to take initiative. So this was about the Keshwanand Bharati case. The next case was the textile workers case. The national textile workers versus PR Ramakrishnan case. PR Ramakrishnan case. So in this case, the court again reiterated its awareness that we are aware that that our powers with respect to implementing UCC are limited. So the court reiterated its awareness of its limitation with respect to UCC, and the court cannot enforce UCC without appropriate legislation. So court said that we can't implement UCC without legislation, without appropriate legislation by the government. So the support from the government in the form of legislation is required. The court is limited in its powers to implement UCC. This was said in the National Textile Workers case. Then we have the famous Shabano case, and Shabano case was in which a 60-year-old woman, she was divorced by her husband and she had 5 children, so she claimed the right to maintenance from her husband, and she appealed. She was given triple talaq by her husband. So she approached the courts, the district court and high court, who ruled in her favor. So her husband appealed against the judgment in the Supreme Court. He said that he had fulfilled all his obligations under the Islamic law. So the husband had fulfilled all his obligations under Islamic law according to the husband, and so he was not entitled to give maintenance to the wife. So what did the Supreme? So under the Islamic law, we can see that under Muslim personal law, maintenance is to be paid only for a 3-month period, which is called the period of iddat. So the 3-month period, the 3 lunar month period, that is roughly 90 days after the divorce, after the talaq, that is the period of iddat. And according to Muslim personal law, the maintenance is to be paid only during this 3-month period. This was according to Muslim personal law. So the husband said that I have complied with the Muslim personal law and I am now not entitled to pay any additional maintenance. So what did the Supreme Court say? The Supreme Court ruled in favor of Shabano in 1985, and Supreme Court said that Section 125 of the CRPC, Section 125 of the CRPC, it is equally applicable to all citizens irrespective of religion, and this section provides for maintenance of wives, children and parents. And the Supreme Court recommended that uniform civil codes should be set up throughout the country, and it ruled in favor of Shabano, saying that Shabano is entitled to maintenance under Section 125 of CRPC, which is applicable to all irrespective of religion. Now, what was the impact of this? So there were nationwide agitations by the conservative faction of the Muslim community. So the Congress government, since it has a substantial vote bank from the Muslim community, so it came under pressure, and Rajiv Gandhi government under pressure, it passed the Muslim Women Right to Protection on Divorce Act 1986 and made Section 125 of CRPC inapplicable to Muslim women. So now Shabano was not entitled to maintenance under Section 125 because it was inapplicable to Muslim women according to the new parliamentary law that was passed by Rajiv Gandhi government. Now this was a kind of Muslim appeasement. It was a regressive policy. Since it was regressive, the majority committee protested against it, and also certain progressive elements, the liberal and progressive elements, they protested against it. And so Rajiv Gandhi government had just appeased the Muslim vote bank. Now since the majority community was protesting, so again Rajiv Gandhi government came under pressure. So because Rajiv Gandhi feared loss in the next election, so what the Rajiv Gandhi government did is that it took another very controversial decision, and that decision was to allow the Hindus to perform their ceremonies and rites in a part of the then structure called Babri Masjid. So in 1989, the government allowed the Hindus to perform their ceremonies or rites to worship in a part of the Babri Masjid complex. So this was another controversial decision, which we know that finally this resulted in a chain of events which led to the demolition of the Babri Masjid. Now we come to the next case. The next case is the famous Daniel Latifi case. The Daniel Latifi case of 2001. So in this case, the Supreme Court. Now in this case, what was Why was it brought? The Muslim Women's Act that was passed by the Rajiv Gandhi government, it was challenged. It was challenged on ground that it violated the right to equality under Article 14 and 15 and also the right to life under Article 21. The Supreme Court said that Supreme Court ruled that this act is constitutional. Supreme Court said it is constitutional. But the Supreme Court tried to harmonize it with Section 125 of CRPC, and the court said that this is constitutional, but the amount that is received by the wife during that period, that is a 3-month period after divorce, it should be large enough to maintain the wife during the iddat period as well as to provide for her future. So the amount that is paid by the husband as maintenance during the iddat period, it should be large enough to maintain the wife during the iddat period as well as afterwards. This was said by the court in the Daniel Latifi case. So the amount should be large enough to maintain the wife for a lifetime or till she is remarried. So under the law of the land, a divorced Muslim woman is entitled to provision of maintenance for a lifetime or till she is remarried. So although the amount will be given only during the iddat period, but it should be large enough to maintain the wife even after the period of iddat, till the time she is remarried. Or if she doesn't remarry, then for the lifetime. So this was the Daniel Latifi case. Then we come to the famous Sarla Mudgal case of 1995. In this case, what had happened was that there was a husband and wife, they had married under the Hindu marriage act, they were Hindus, but the husband, he converted to Islam. He converted to Islam and then he married another woman without divorcing his first wife. So then the case was filed in the court, and the court said that Hindu marriage solemnized under Hindu law can only be dissolved on any of the grounds specified in the Hindu Marriage Act of 1955. And the question was whether the Hindu husband under who had married under Hindu law, by embracing Islam, can he solemnize a second marriage? So the court said no, it cannot be done. Conversion to Islam and marrying again would not by itself dissolve the Hindu marriage. Under the act, and thus a second marriage solemnized after converting to Islam would be an offence. So this if that person marries a second wife after converting to Islam, then it is an offence under section 494 of IPC. And in the Sarla Mudgal case, the court again stressed on the importance of UCC across the country. Now we come to the next case. The next case is the John Balam case. Before the John Balam case, there was the famous Saira Bano case. So what happened in the Saira Bano case? Saira Bano case of 2017. In this case, the court had declared triple talaq as illegal and also had stressed on the importance of a gender-neutral law and uniform civil code. Then there was the famous John Balam case, and in this case related to a priest from Kerala, a Christian priest from Kerala. So he challenged the constitutional validity of Section 118 of the Indian Succession Act, which was applicable to non-Hindus in India. So what Mr. Balam Tom, who is a Christian priest, he said that this section 118, it imposes unreasonable restrictions on the donation of property by non-Hindus for religious or charitable purposes by will. So it imposes unreasonable restrictions on donation of property by Christians for religious or charitable purposes by will. So this section he challenged this section in the court, and the court then struck down this section as unconstitutional. So what is important for us is that in this case also, court had stressed on the importance of UCC. Then the next important case regarding UCC, it was the Joseph Shine case. So in the Joseph Shine case, what had happened was, Joseph Shine case of 2018. In this case, the court said that adultery will not be treated as a criminal offence. It will not be treated as a criminal offence. And court declared Section 498 of IPC and Section 198 of the CRPC as unconstitutional. Why? Because Section 498 of the IPC only charges the man with the offence of adultery. Only the man is charged. the woman is not charged with the offense of adultery. Only the man is treated as a criminal. So this is not a gender neutral section. So hence it was struck down by the court. And section 4, 198 of the CRPC, it says that only the aggrieved husband of the woman, he can file a case in court regarding adultery. No one else can file a case in court. So this is also discriminatory because it is not gender neutral. And these two sections, they were treating the woman as a property of the husband. So these were regressive in nature, and hence they were struck down by the court. Because adultery, if the offense of adultery is being committed, then it is wrong to charge only the man with the offense of adultery. And only the aggrieved husband is empowered to file a case in court. No one else can file a case. These two discriminatory sections, they were struck down by the court, and the court again reiterated the need for a uniform civil code and gender neutral laws in this famous Joseph Stein case of 2018. Now, next important case dealing with uniform civil code is the famous John Polo Contino versus Maria Luisa case of 2019. So in this case, court praised Goa for implementing uniform civil code, and court emphasized on the need for pan-India implementation of uniform civil code. Now we will come to the stance taken by the law commissions in India. So the first was the 2018 21st Law Commission. It said that time is not yet right for implementation of UCC. Formulation of UCC is neither necessary nor desirable at this stage. This is what the Law Commission said. The Law Commission said, the Law Commission of 2018, that is the 21st Law Commission, it said that instead of bringing in a law for uniform civil code, we should try to reform the personal laws by making amendments in the personal laws itself. So this 21st Law Commission, it suggested amendments in the personal laws. It also gives certain other suggestions, like having a uniform age of marriage for girls and for men and women. For men and women, there should be uniform age of marriage. That is, it should be 18 years for both men and women. At present, it is 18 for women and 21 years for men. So the uniform age was proposed by the Law Commission, and the Law Commission also proposed that the provision of Hindu undivided family getting tax benefits, it should be done away with. This should be done away with. So this was about the 21st Law Commission stance on UCC. It said that UCC implementation is not necessary or desirable at this stage. Then there was the 22nd Law Commission under Justice Rituraj Awasthi. Under Justice Rituraj Awasthi, the 22nd Law Commission, it took the views of different stakeholders. It gave a period of 1 month for all stakeholders like the general public and the religious organizations to submit their views, their opinions regarding UCC. And this Law Commission is still formulating its report. So this was the 22nd Law Commission. Also, a parliamentary standing committee had been formed regarding giving recommendations on implementation of UCC. So this was about the law commissions. Then we come to the constitutional provisions regarding personal law. So entry 5 of the concurrent list, it empowers the central and state government to legislate on personal laws. Now the laws relating to marriage and divorce, infants and minors, adoptions, wills, intestacy. What is intestacy? Intestacy is when a person dies without a will. Then how will the property of the person be distributed among his relatives, that is the wife, children, parents, etc. This is called intestacy. Intestacy and succession, joint family and partition, all matters in respect of which parties in judicial proceedings were immediately before the commencement of this constitution subject to their personal law. So in brief, entry 5 of the concurrent list deals with personal laws. It empowers both the central and state government to legislate with respect to personal laws. Now recently Uttarakhand state has passed a uniform civil code, and it gave the law went to the president for assent. The law was sent to presidential assent. Now this law, it was overriding several national laws like the Special Marriage Act 1954, the Hindu Marriage Act 1955, the Sharia Act 1937, and hence it was of of grave national importance, and therefore it was sent to the President's approval before implementation. Now we will briefly go to the Constitution. What are the powers of governor to reserve a bill? So governor is obligated. It is obligatory on the governor to reserve a bill passed by state legislature for President's consent if the bill endangers the position of state high court. One very important thing, that if the bill endangers the position of state high court, it has to be sent for presidential assent. It is compulsory. Then, if the bill is against the provisions of the Constitution, then it is sent for the President's assent. If the bill is opposed to directive principles, it is sent for presidential assent. If it is in the larger interest of the country, of grave national importance, or deals with compulsory acquisition of property under Article 31 of the Constitution, 31A of the Constitution, then it is sent for presidential assent. So this was in brief about the constitutional provisions. Next, we are going to come to the main provisions of the Uttarakhand Bill, Uttarakhand Uniform Civil Code Bill. What are the main provisions that are listed in the UCC implemented by the Uttarakhand government? Now, the main provisions is first provision. The first provision says that the marriage can be only between a man and woman, so gay marriage is not allowed. Gay marriage is not allowed. Minimum age of marriage is to remain the same, 18 years for women and 21 years for men. And in case of non-compliance with this provision, suppose a woman marries before 18 or man marries before 21, then there will be 6 months jail or 25,000 rupees fine. Then the marriage should be registered within a 60-day period, and if this is breached, if this provision is violated, 10,000 rupees fine will be charged. If suppose a marriage has taken place after the implementation of UCC in Uttarakhand and it is not registered within a 60-day period, then there is going to be a 10,000 rupees fine. And now dissolution of marriage in violation of the UCC norms, that is the Uttarakhand UCC norms, will be punishable with 3-year jail. So 3-year jail term for violation. Then the provision is that polygamy, bigamy, nikah halal, iddat, triple talaq, all these practices are banned, and if somebody carries out these practices, then punishment will be 3-year jail period, 1 lakh rupee fine, or both. Then the most important, the most controversial provision regarding this UCC is about the living relationships. So the living relationships, living couples need to register with the registrar within a month of the beginning of their relationship, and their details they will be inquired into by the registrar, and the registrar can conduct inquiry to establish the validity of their relationship. Also, the registrar will inform the police about their registration, and also if these couples are to terminate their relationship, if they want to end their relationship, then also they need to go in person before the registrar, and then also to inform the police also before terminating or ending their relationship. Suppose one of the partners is trying to end the relationship, is wanting to end the relationship, so he will have to register with the registrar, and also the copy will be given to the other partner also, and information will be given to the police. Now, this provision is very controversial because people are saying that this is intruding into the private sphere, and the Uttarakhand government is giving an argument. The argument given by the Uttarakhand government for this making registration of living relationships compulsory is that it will facilitate rent agreements. It will help living couples in getting easy rent agreements. They will be able to take living space on rent easily. Earlier it was difficult. Now they cannot rent or buy property without registering their living relationship. Now child born out of the living relationship will be considered a legitimate child. Now this is also being opposed by conservative sections because this will mean that the child will enjoy right to inheritance also, and this is being opposed by the patriarchal nature of our society and the conservative elements. Now must inform that this we have already seen that the living couple must inform officials on termination of the relationship, and if a woman is deserted by her living partner, then she is entitled to maintenance. Then the next provision regarding the bill is that if there is a divorce or domestic dispute between the two partners in marriage, or in a live-in relationship, then the custody, if there is a child, then the custody of the child is to be with the mother for a period of 5 years, notwithstanding anything else. So in case of divorce or domestic dispute, custody is going to be with the mother for a period of 5 years, notwithstanding anything else. Also, the this one of the controversial things in this UCC is that for marriage the age for the girl is to be 18 years, but for living relationship, if any of the partners is below 21 years of age, then the officials are required to inform the parents of these two of the partner of these partners. Then if the living couple does not register their relationship within a month, then they can face an imprisonment of up to maximum 3 months. And if the living couple gives false information to the authorities, then they can face an imprisonment up to 3-month period, a fine of not more than 25,000 rupees or both. So I summarize it again. If the living couple does not register their relationship within a 3-month period, then they will face a within a 1 month period. Sorry, if they don't register their relationship with the registrar within a 1 month period, then they can face a maximum imprisonment of 3 months. And if they give false information to the authorities, then they can face a jail term up to 3 months or a fine up to 25,000 rupees, not more than 25,000 rupees fine, or both. So this was about the provisions of the UCC that has been implemented by the Uttarakhand government. Now, one more important provision of this UCC is that in the UCC of Uttarakhand government, it says that if like one of the partners in a marriage, they change their religion, if they change their religion without consent of the other partner, then the other partner will have the right to divorce, full rights to divorce her partner. Suppose one of the partners changes the religion without consent of the other partner, and the other partner has the full rights to divorce and also full rights to maintenance. So suppose the couple is a Hindu couple and the husband changes to Muslim religion without informing the wife, without taking her consent. So the wife can seek divorce from her husband and she is also entitled to full maintenance rights. So this was in brief about the provisions of this bill. Now the significance of these provisions. It aims to focus on gender equality and also it gives equal property share to Muslim women, because existing personal law they give only 25% share to the Muslim women. And this bill is progressive because it gives equal property share to Muslim women. Now exemption. The scheduled tribes, they are exempted from the purview because they have their own customary laws and it is not appropriate to intrude into their cultural sphere. So the tribal population of Uttarakhand is 3% and they have been exempted from the application of provisions of the UCC by Uttarakhand government. Because special status has been accorded to the tribal communities, we know under the schedule 5 and 6 of the constitution, special status is enjoyed by the tribal communities. Now concerns regarding the bill, the minimum age will remain the same, 18 for women and 21 for men. So some people are arguing for uniform marriageable age. The Law Commission of 2018 had also recommended that the marriageable age should be uniform for men and women. Then mandatory registration of living relationship. So this is the most controversial provision because people are saying, the critics are saying that it will intrude into the private sphere. This is state encroaching upon the private sphere because living relationships they are based on the premise that why do people enter into such relationships? Because these relationships do not have the obligations of marriage. They don't have all the obligations and responsibilities that are associated with marriage. So people find it convenient to enter into these living relationships. So this is ignored by the bill. And mandatory registration of these living relationships and informing the police on both commencement and termination of these relationships. This is also treated as a controversial provision. This can subject these vulnerable couples to harassment by the authorities as well, because many couples which are interreligious couples, they enter into such living relationships and they are vulnerable because they can be harassed by elements in the society. So this is going to further increase their vulnerability. they can be subject to harassment by the authorities as well. At present, there are overarching powers that are given to the registrar. So the registrar can even refuse to register the living relationship. So this further increases the vulnerability of the living couples. So mandatory requirement of registration of living relationship and criminalization. So if they are not registering within 1 month, they are not registering the relationship status within 1 month, then it is an offence and they can be subject to 3 months of jail. And on false information, they can be subject to 3 month jail and a fine of not more than 25,000 rupees. So this confers a disproportionate power on the state to penalize consensual relations and violate individual autonomy. Now we are seeing the concerns. The overriding power to registrar. We have already seen that registrar has the power to examine the statement submitted by the couple and can conduct inquiry. He or she can also refuse to register the relationship. And termination of relationship also requires notice to be submitted to registrar. So this is overriding power to registrar, which is a concern associated with this bill. Then criminal penalty. Imprisonment or fine or both if the statement is not filed. So if the living couple does not register within 1 month period, then they can be subjected to maximum of 3 years of jail. And in case of false information, they can be subjected to three months of jail. This is 3 months. So if they don't register within 1 month, they can be subjected to maximum 3 months jail. In case of false information, they can be subjected to 3 months jail and a fine of not more than 25,000 rupees. So as you see, couple will be penalized for submission of false information. That is 3 months jail, not more than 25,000 fine, or both. And if they don't file the statement within 1 month, then 3 months jail maximum. So the registrar will inform the details of the living relationship to the police station also, whose jurisdiction governs the couple. So this is also a controversial provision of the bill. Then concern raised that it is infringing on the individual autonomy, because the foundational reason of a living relationship is that it lacks the formal structure and the obligations of a marriage. It can lead to excessive moral policing because involvement of police and on lack of compliance with the provisions of this UCC, there are civil and criminal consequences as we have already seen. And it violates the right to a dignified life because 1 month limit for registration. Now the couple is required to register within 1 month. So it infringes on their right of free decision making. Then what are the suggestions? Suggestions with regard to this bill is that the policy should be clear and in sync with the constitution, because just because these living relationships they are considered undesirable by the society, by the conservative majority, then it is not the insufficient, it is not the sufficient reason for their criminalization. So it is not appropriate to criminalize these, and the punishment given should not be disproportionate. It is not appropriate to criminalize these relationships because just because they are considered undesirable by the conservative elements in the society. Then the Supreme Court had given its views in the adultery judgment. That was the Joseph Stein judgment of 2018. The Supreme Court stressed on the right to privacy. It is not the lookout of the state to interfere in the lives of individuals. So this is what the Supreme Court said in its famous adultery judgment. Then in the famous case Puttuswamy judgment of 2017, Supreme Court again stressed on the right to privacy. So the UCC, if any state is framing uniform civil code, it should take these concerns into mind. The right to privacy of individuals. State should not be over-intrusive in the personal sphere. Then preventing discrimination and fostering inclusion should be taken into consideration before framing any law, because mostly intercaste and interreligious couples, they face the prospect of severe harassment by the authority. They also face a lot of social stigma in our country, and they are sometimes also subject to the horror of honor killings. So the proposed law with this proposed UCC, it has a high regulatory content for living relations. So it is going to affect the vulnerable couples in a disproportionate manner. So the suggestion is that the state should adopt an inclusive regulation. Then Article 21 deals with the right to life, and right to marry is an integral part of the right to life. So this should be taken into consideration by the state while framing any legislation, including Uniform Civil Code, and women's right of autonomy over their body. So women's right of autonomy over their body and their right to privacy should be an integral part of any legislation. Then also the horizontal application of right to privacy. Protection of the right to privacy against non-state actors. This should be taken into consideration. There is a need for regulation of how information can be stored, processed and used by the non-state actors. So privacy protects an individual from interference from both the state and non-state actors, and individual should be allowed to make autonomous life choices. So this right to make autonomous life choices should not be infringed upon by the state. In this, the mandatory registration of these living relationships and informing the police, it can subject to the living couple to harassment by the police. Also, the information might leak to other elements of society, and the couple may face the prospect of harassment from other anti-social elements also. And sometimes even the relatives may resort to harassment of the couple. So this right to protection against non-state actors. Both state and non-state actors, they should be prevented from interference in the personal sphere of individuals. The individual should have the right to autonomous life choices. Then proportionality test. So the punishment should be least restrictive and effective. It should be least restrictive, it should not be over restrictive, and should also be effective. Now we come to the different pros and cons associated with Uniform Civil Code. What are the advantages of Uniform Civil Code, what are the disadvantages, and what is the way forward. Advantages include it simplifies legal system. At present there are thousands of personal laws in the country and many of them are not codified. So the courts have to legislate on lots of personal laws and there is a lot of confusion created. For example, in a few years back there was a case in which from the Meena community, there was a couple from the Meena community and the husband wanted to divorce his wife, and these two people, they were married under the Hindu Marriage Act. So husband wanted to divorce his wife and he moved court. So when he moved the court, the wife presented her counter argument and wife said that since we are a tribe, we are the Meena tribe, and in Meena tribe there are no rights of divorce. So she said that my husband cannot see divorce from me. This was the wife's stand. But the husband said that since we were married under the Hindu Marriage Act, the husband actually, the court ruled in favor of the wife. The subordinate court, it ruled in favor of the wife. Then what did the husband do? He went to the Delhi High Court. He went to the Delhi High Court and he said that since the couple had been married under the Hindu Marriage Act of 1955, so the right of divorce should also be under the Hindu Marriage Act. Why should the tribal rules apply in case of divorce when the marriage was under the Hindu Marriage Act? So the court listened to both sides. The wife had been saying that since we are a tribe and in our tribe there is no right to divorce. Court heard both sides and finally the court said that this confusion would not have been created if there was a uniform civil code across the country. So the court in a way supported the implementation of uniform civil code. So we can see that implementation of uniform civil code is going to remove confusions and it is going to simplify the legal system. It is also going to promote gender equality and women empowerment. And also it is going to further the principle of secularism as well as national integration, and it is going to lead to a modern and progressive society. It will also enhance India's image internationally as a progressive and inclusive nation. So these are the positive points. These are points in favor of a uniform civil code. What are the points against uniform civil code? One is that there is lack of consensus. There is lack of consensus between different stakeholders with respect to implementation of uniform civil code. They are not on common ground. So implementation is difficult. Then there are implementation challenges. It is very difficult to codify. Lot of personal laws, they are not codified. So first these laws need to be codified and then there has to be discussion, deliberation, and only then the UCC can be implemented. So this process faces a lot of implementation challenges. There will be many sections of society who are dissatisfied with the UCC. So there are a lot of challenges. Then it is a threat to religious freedom. So Article 25 to 28 of the Constitution, that are fundamental rights, they deal with the right to freedom of religion. So they give the individuals freedom to practice, profess and propagate their own religion. So the critics are saying that this implementation of UCC, it is going to infringe on the right to freedom of religion. Also it is a threat to cultural diversity. The critics say that UCC implementation will threaten the cultural diversity within the country. Also, the minority community sometimes fears that it is going to lead to implementation of the imposition of the views of majority. It is going to lead to imposition of the majority view over the minority community. They say that the majority is going to implement its views, its norms on the minority by means of implementation of UCC. As we can see that recently OIC, Mr. OIC, who is a leader of the All India Majlis of the AIMIM, All India Majlis e Musliman. So OIC, what did he say? That the Uttarakhand UCC, it is nothing but another form of the Hindu code bill which is being forcibly imposed on the minority community. The argument given by OIC was that since that the Uttarakhand, if it is a uniform civil code, then it should also deal with the Hindu. It should also look into the provision of Hindu undivided family. At present, the Hindu undivided family is given tax benefits. So OIC said that these tax benefits should be taken away. Why are you only changing the laws related to minority? The Hindu and the laws related to majority, that is the Hindu undivided family getting tax benefits, this should also be done away with if the law is to be truly uniform in nature. So there is the fear of majoritarianism, that the majority community is going to impose its views on the minority by means of UCC. Then threat of a social unrest. It is often feared that implementation of UCC will lead to social unrest because the dissatisfied sections of society, they are going to launch agitations against this, and it may lead to riots or any other violence also. Then it is going to undermine federalism, according to critics, because at present under entry 5 of the concurrent list, personal laws are covered, and both the center as well as state have the right to legislate on this. Now, if the center imposes a uniform civil code on all states, it will undermine federalism. It will restrict the freedom of states to implement such laws. And what is the way forward? Way forward is that there should be dialogue and consultation between different stakeholders. All the religious communities, they should come together and they should try to reach a common ground. Then piecemeal approach should be adopted. A gradual approach, a piecemeal approach should be adopted to codify different personal laws, and they should be put to public debate and scrutiny, and this will arouse public consciousness. Also, there should be gradual implementation of UCC in a phased manner, and it should start from areas of least resistance. To start from those areas where there is least resistance and gradually expand it to the rest of the country. So gradually, first we implement it in areas of least resistance, and then as the society it gets more mature, we implement it in the rest of the country. There should be gradual implementation. Then inclusivity. The UCC should be implemented in such a manner that it respects the religious diversity. The religious diversity should be respected, gender equality should be promoted, and justice should be promoted. So it should have an inclusive approach, and it should respect diversity. It should respect diversity and it should have an inclusive approach. It should promote gender equality and justice. Then, while the UCC is being implemented, then there should be monitoring of the impact. The impact should be monitored and evaluated. Because by monitoring and evaluating the impact, we can actually adjust the laws in accordance with the needs of the society. So this was about monitoring and evaluation of the impact of UCC so that we can make adjustment in case there is social unrest or the needs of society are not being met. Then there should be political will. Strong political will is required to navigate through the challenges in the UCC implementation, because when we implement UCC there are going to be many challenges. We need to bring all stakeholders, and there needs to be common ground. So there are going to be huge challenges, and certain sections will be dissatisfied, so they need to be pacified. So a political will is very important to navigate through the challenges in the implementation of uniform civil code. So this was briefly about the uniform civil code. We will summarize this video briefly. So first we studied that On the Independence Day speech on 15th August 2024, the Prime Minister stressed on the implementation of UCC. Implementation is challenging because the present government is a coalition government, and the JDU and TDP, which are supporting the government, they enjoy a substantial support of minority community. So it is the government needs to tread a cautious path if it needs to implement the UCC. The opposition parties, they are opposing the implementation of UCC, saying that it is a kind of imposition of the view of majority community on the minority. So they are instilling the fear of majoritarianism in the minority community. Now, PM Modi, in his Independence Day speech, he said that he is trying to place feminism as opposed to as opposed to the view taken by the opposition parties. So it is kind of feminism versus secularism. So PM Modi is stressing on the rights of women. Modi says that the rights of women, they will be respected if we implement the UCC, because at present the Muslim women do not enjoy the equal rights to property and equal rights of divorce. So the issue of feminism is being raised by the BJP against the stand of secularism taken by the opposition parties. Then we had studied about the definition of uniform civil code. It is a national civil code which applies to all sections of society irrespective of their religion. Then we have seen that Goa is the only state with UCC, which is implemented UCC, plus now Uttarakhand is also going to implement UCC. And Goa and Assam have also said that we are going to implement the UCC. Now Assam has got a substantial population of scheduled tribe community. Not Goa and Assam, Gujarat and Assam. Assam has got a substantial population of the scheduled tribe community, and perhaps the interests of these tribes need to be taken in consideration while implementing the UCC. Then we studied about the different cases relating to uniform civil code, like the Shabano case, in which UCC was emphasized, implementation of UCC was emphasized. This was reiterated in Sarda Mudgal and John Balamtom case, also in the Shaira Bano case, in the Joseph Shine case, in the Kotino case of 2019, and then in the Pandalal Bansila judgment, what the court said was, court adopted a more practical approach. Court said that one-stroke implementation of UCC can prove to be counterproductive. Also in the Keshwanand Bharti case and the National Textile Workers case, the court had given its views regarding UCC. And we studied about what was the status in the colonial era regarding the personal laws. So the Lex Loci report has said that personal laws codification is not advisable, but codification of crimes, evidence, and contract, these should be carried out. And recommended personal laws of Hindus and Muslims should be kept outside such codification. Then the Queen's proclamation said that the British will not interfere in religious affairs. So criminal laws were codified and were common for the whole country, but personal laws, they were governed by separate courts during the colonial era. Then we studied about the Hindu Code Bill and the diluted version of it, which was passed in the form of 4 different laws. Then we studied in detail about the different cases, like the Shabano case, the Daniel Latifi case. In the Daniel Latifi case, the court had ruled that stated that the Muslim Women's Act was constitutional, but the amount received by the wife during Iddat period should be large enough to maintain her during the Iddat as well as afterwards, to provide for her future. So the amount during Iddat should be large enough to maintain the wife during Iddat as well as after that, till the time she is remarried, or if she doesn't remarry, then till her lifetime. Then Sarla Mudgal case, the court said that on conversion to Islam, only for marrying again is not allowed, and the court stressed on importance of UCC. Then we saw the John Balamtom case, the John Paul Contino case, in both of which the importance of UCC was emphasized. Then we studied about the 2 law commissions. The 2018 21st Law Commission said that UCC's implementation is not desirable at this stage, and the 22nd Law Commission took the views of different stakeholders regarding UCC. Then we studied in detail about the provisions of the Uttarakhand Uniform Civil Code. in which the provision regarding mandatory registration of live-in relationship, this is a very controversial provision, and the Uttarakhand UCC, it prohibits child marriage, it proposes a uniform age for girls marriage across all the regions, it prohibits polygamy, nikah halal, ida, triple talaq, etc., and prescribes punishment for them. Then we studied about what are the shortcomings in the UCC implemented by the Uttarakhand government and what should be done, what are the suggestions, the concerns and suggestions. Then we came to the different pros and cons of the Uniform Civil Code, the pros and cons and the solution, that is the way ahead. So this was about the Uniform Civil Code. Thank you.